Hi there. Thank you for tuning in. This is Larry Donahue with Law for Small Business. I am one of the founding partners of the firm, and I want to talk to you quickly about dissolving a company, whether we're talking about an LLC or corporation or any sort of corporate enterprise. We have the product. We can certainly do that for a low-cost price plus state fees. What I want to warn you about is dissolving a company is important, and it's critical to moving past the company and winding down the organization. However, I want to use a little analogy here. I'm going to use this little soap dispenser as an example of the analogy. Inside this soap dispenser, let's call it, we have some poison, some toxin. In the company, it's debt, liability, some sort of thing we're trying to get rid of, trying to walk away from. Well, currently, the LLC or the corporation, the entity, represents the bottle, and it's shielding us, protecting us from the poison that's inside this bottle. And so what happens if I dissolve the bottle, right? That poison is going to leak all over me. I'm not actually protecting myself. I'm not making this bottle go away. I'm simply dissolving the shell of the bottle, and the toxins inside that bottle are now exposed to me personally because I'm holding the bottle. This is the same kind of analogy when we talk about dissolving an LLC or a corporation. So if you are wanting to hire us to help you dissolve a company because you're trying to get away from debts, get away from some liability or obligation, dissolving is not the answer. What happens is you get rid of the very thing that's protecting you personally from that liability. Use this example. You dissolve that shell of a company. Now, all those liabilities, where do they go? They're going to go to whoever the owner or owners are. So you've just removed the only protection you have from personal liability associated with your company. So use this as an example on how that works. So if you have obligations and so on you're trying to get away from, dissolving the company is not the answer. What you want to do is talk to a bankruptcy lawyer. You know, we're not talking personal bankruptcy unless we are, but you want to go through a formal legal process to discharge the debts and obligations of that organization if you want to protect yourself personally. There's no way of walking away from that. There just isn't. So that's warning number one. Now, if you don't have any debts, liabilities, or obligations or anything like that, then yes, dissolve your company. That's best. But I do want to warn you, just because you've closed and dissolved your company doesn't mean you may not have an obligation down the road. What do I mean by that? You could close and dissolve your company, and a lawyer can still sue you from another state. And they may or may not know you closed or dissolved your company, or they may not even care because they don't really care about the assets of your small company you dissolved. They care about going after you personally. So you really need to ask yourself, what kind of business did you have? What kind of risks do you have? And maybe you don't want to dissolve it. Maybe you want to keep it around for a while. And so ask yourself if you have that issue. And if you think maybe it makes sense to keep it around for a little while, how long? The answer is statute of limitations would be sufficient in whatever state or states you're doing business in. And usually it's statute of limitations associated with written contracts would probably be the best thing here, although everybody's needs and issues are different. You know, if you're worried about tax debts or obligations, there's a longer window there. I don't remember exactly what it is. You need to look it up. I want to say 7 years, but I could be wrong about that. The statute of limitations for written contracts in many states is 6 years, but again, you should double check that as well. Now, if you don't think you're going to have that harm or damage, then you can dissolve the company. But I do want to suggest that you keep the registered agent active. Why would you want to do that? You dissolve the company. Why do you need the registered agent? Well, the answer is if some unscrupulous lawyer somewhere tries to sue you or the company, you'll get the notice of that potential lawsuit, and then you can defend yourself or do what's necessary to protect yourself. If you shut down the registered agent, you may never get a notice of a lawsuit. And will that stop a lawsuit? Of course not. So that lawsuit will go forward, and then you could have personal liability attached to a ridiculous lawsuit that is totally unjust and ridiculous, but you never defended yourself. Now you have a default judgment, and it's almost impossible to get rid of a default judgment. But they can do a default judgment in New York, and you could be located in New Mexico, and they can perfect that judgment in New Mexico and go after your assets without any ability to do anything about it. Now, how do I know that? Because I've been a lawyer 30 years, and we see this happening time and time and time again. So, not trying to scare you. I just want you to do the right thing. And so I'm going to end on a note by saying, hopefully this makes sense to you. And if it doesn't, or you're concerned, I would recommend either we sell 30-minute business attorney consults. We're not licensed in every state, though. You will be best served talking to a business lawyer in your home state. And if you don't want to do that, you can certainly talk to us. We can give you some really good general guidance and issues. Although, if you're in Kansas, I don't have a lawyer licensed in Kansas. I'm not going to be able to tell you what the exact statute of limitations are. So that's why you might want to talk to a Kansas lawyer. So that's it. I wish you the best of luck, and thank you for tuning in.